Good evening, everybody. Today is Wednesday, 9 o'clock, and we are having our Legally Speaking event. And today's event is dedicated to discrimination and specifically how to file a complaint with the EEOC, or Equal Employment Opportunity Commission. The law says that somebody who is working for an employer should be free from discrimination and retaliation based on different specific features like national origin, sex, gender, transgender, sexual orientation, race, color, and if an employee is treated unfavorably due to those particularities, then an employee has a right to go to court and hold the employer responsible for this conduct. There are different laws that protect employees on different levels. Federal law, the main law would be Title VII. State law, human rights law in New York is New York human rights law. And in New York, we also have New York City human rights law. New York City human rights laws are actually providing the broadest spectrum of protections based on different categories, wider categories than the Title VII federal law. But of course, to get to the federal court, somebody would have to have a federal cause of action in order to be able to present their claims in federal court. How does it work? Well, the federal law actually says that if somebody would like to sue an employer in federal court, first they have to file an administrative complaint with EEOC. Under the law, the person has 180 days from the adverse action, the action they're complaining about, the action that they consider to be discriminatory, to file that action with the EEOC. It's actually, in New York, it's a longer period of time. This period of time is stretched up to 300 days because of the special agreement between the EEOC and New York State Division of Human Rights. But to be on the safe side, we all should remember it's 180 days. This is our deadline to file a complaint about discrimination that we allege is going on. How do we do that? Well, in New York, a person should contact New York field office and gives them a call. Usually what they do first, they provide a questionnaire on intake. However, the complaint is not filed unless the person submits what's called Form 5. Form 5 is actually only a one-page document that asks for very basic information from an employee, like their address, name, who the employers are, what their phone number, if they know, address, and there is a paragraph asking, describe what happened to you. Very often when the person is working with an attorney, they would just say, please see attached, and submit a separate affidavit attachment to that Form 5. So that's the technicality of it. So basically, if somebody would like to complain about the employer to EEOC, they need to call the hotline, get the intake down, sign the form, and have the complaint submitted, or the charge, how the EEOC would call it. Now, when a person can do it and should do it, when a person should go to the EEOC? Well, first of all, under the law, in order to maintain a federal cause of action, an employer, not anybody or any entity can be sued in federal court. An employer has to have at least 15 employees. So it has to be a sizable employer. It cannot be somebody who is employing you. You work at a small business, there is only an owner and you. That's not going to work. The employer has to have, under federal law, at least 15 employees, and under the law of the state of New York, the employer has to have at least 4 employees. Then, very often, before you go to the EEOC, it would be a good idea generally to first raise this issue of discrimination and feeling uncomfortable with an employer itself. So basically, a person should complain to the management, to the human resources, or to the owner of the company, saying, hey, I feel that I'm being mistreated, and I would like that conduct to be stopped, or the situation be addressed. An employee has a right to do it, even if it's all an employee's head. The employee has a right to complain and be protected, meaning that the employer cannot retaliate an employee, even if an employee does not have a real case of discrimination. There are different situations at work. Maybe somebody is just too sensitive and they believe that they've been discriminated against, or maybe something really is going on. Whatever the situation is, if you feel uncomfortable at work, at the work environment, you should know your employer, your boss know about it. And whatever the issue is, employer has an obligation to address it. If the issue is serious and if the complaint is serious, the employer has to conduct, actually in every case, I would say, an employer has to conduct an investigation of your allegations. The depth of investigation and what needs to be done, of course, depends on the complaint, but employer has an obligation to conduct an investigation of your complaints to the employer. If it doesn't help, or if you believe that going to the employer is not going to resolve the situation, then you should go directly to the EEOC. Now, in New York, we have two bodies. It's EEOC that accepts these complaints, and New York State Division of Human Rights. A person has a choice. There are slight differences of the consequences. What if your complaint gets denied? Depending on where it was initiated, New York State Division of Human Rights or EEOC. There are differences. So it would be generally a good idea to consult with an attorney to see how the case should proceed. But in any event, in order to get to federal court, a person has to submit that administrative complaint. What should be in the complaint? Apart from the biographical information or information, just intake information. The complaint should provide details of what's going on and why you believe that you are being discriminated against. That is, names of the people who are discriminating against you, what they did, when, what did you have witnesses, what can they testify, what did they see. The complaint should be as detailed as possible, because the more details you provide, the more believable it is. Sometimes the only witness of what's going on is the person, him or herself. Let's say somebody was inappropriately touched and there is no there is no video, there is no nothing. There's just that person's testimony. That's why it's important that the person is consistent and as detailed as possible. And it's when he or she is providing submitting the complaint. The process is such that the employer will be informed about the complaint and then will have an opportunity to respond to the charges. As you can imagine, most employers will have an attorney helping them to do that. That's why it's important for you to have an attorney helping you. Because the civil rights law in this area of employment discrimination, is very complicated. It changes all the time. A little choice of words can affect the outcome of your case, believe it or not. And that's why, if possible, you should always try to have an attorney helping you as well, because there will be a lawyer helping an employer. After employer submits its answer, you as a charging party will have an opportunity to submit a reply. So whatever evidence you have, paper evidence, videotapes, maybe audio tapes, you should present them to the employer, to the EEOC. Why it's important? Well, EEOC does have a power to suggest to the employer to resolve the situation in a certain way. But most importantly, if EEOC believes that you have a compelling case, it can bring the lawsuit on your behalf, on behalf of the class members that you would represent. That's why it's important. That's why it's important to work with an attorney. EEOC usually should resolve the case and bring its determination on the case within 180 days. Very often it does not happen because it's very, very busy. There are many complaints. What happens in this situation? And a person feels that he or she has a compelling case and they would like to go to court. In this situation, a person would ask the EEOC to issue a fast decision, or what we call administrative dismissal. So the person can go to court, because without that dismissal and without this decision, what we call a right to sue letter, the person will not be able to go to federal court. Or if the person files his or her case in federal court without the right to sue letter, that complaint will be dismissed. That's pretty much the main steps of how to move your case from ground zero to federal court. That's what you need to do. You need to file a complaint. You should be as detailed as possible, provide as many details and witnesses information and all other evidence that you have as possible. And then if the EEOC does not render its decision within a reasonable time, you can have them to issue you a right to sue letter without their determination, so you can go to court. What is the process with New York State Division of Human Rights? It is sufficiently the same. Why? Well, it's because the EEOC and New York State Division of Human Rights have a work sharing agreement, meaning that even if you file the complaint with EEOC, it's likely that it's going to end up in New York State Division of Human Rights, and they're going to be the ones who conduct an investigation, because sometimes they do conduct that investigation when they call employer, or they do undertake some other measures and they see what's going on. One important point that I wanted to focus on was what happens if, let's say, New York State Division of Human Rights says that they believe there is no probable cause that your allegations are true. In this situation, the person can still go to federal court. It's very important. Even if New York State Division of Human Rights said that your allegations are not sufficient or do not amount to the level that they believe you've been discriminated against, you can still go to federal court. The only difference here is that in federal court, you will lose and will not be able to assert state causes of actions. Or only federal, you will be able to continue with the lawsuit only under the federal law. So this is the basics of how to take your complaints from initial stage to federal court. I always welcome questions regarding employment discrimination through my website. I actually have now a new website for that. It's called www.workharassmentattorneys.com. Or you can always find me at www.shautsova.com or by calling 917-885-2261. And I'll be happy to answer your questions. I do provide free consultations for employment discrimination cases. And I hope you enjoyed this little presentation on the issue. And please submit your questions through my website. I'll be happy to answer them. Thank you very much.